This amendment also amends Article 243 of the Constitution to state that the Parliament would now, after this amendment, not have the right to amend any law which deals with the appointment, extension, or reappointment of service chiefs. This amendment, the People's Party has also supported this constitutional amendment. So the People's Party will now have the interesting distinction of having a pivotal role in both framing and destroying the Constitution. Any member of a political party may not cast his vote contrary to the party's directions, and any votes cast in a manner which is inconsistent with the party's directions cannot be counted. Well, perhaps the very first issue underpinning the government's proposed 26th Constitutional Amendment Act is the very title of the act. Given the text of the Amendment Act, perhaps a more accurate title would have been the Destruction of the Constitution Act 2024. Now, before delving into the merits of the Act, it may be important to recapitulate that the Supreme Court has previously, District Bar Rawalpindi case of 2015 held, that the right to amend the Constitution does not include the right to alter the Constitution's basic structure. The right to amend does not include the right to destroy the Constitution. Nonetheless, as will be palpable by delving into the text of this amendment is tantamount to destroying the Constitution's salient features. Now, it's also interesting that amongst the parties who are the purveyors of this amendment, the People's Party has also supported this constitutional amendment. So the People's Party will now have the interesting distinction of having a pivotal role in both framing and destroying the Constitution. Now, amongst the important changes that this amendment brings about is a change to Article 63A of the Constitution. Now, Article 63A pertains to disqualification of parliamentarians on grounds of defection. Last year, in the Supreme Court Bar Association case, the Supreme Court held that a member who votes contrary to his party's directions in matters involving the election of a Prime Minister, a vote of no confidence of the Prime Minister, or an amendment to the Constitution, such vote which is cast in a manner inconsistent with the direction of the parliamentary party will not be counted. Now, this decision was critiqued and assailed by a number of lawyers, members of the legal fraternity, members of the civil society, given its inconsistence with the express command of the Constitution. So perhaps an amendment to Article 63A may not have been as controversial if it was not for the timing of the amendment. Now, let us also remember that there was also a huge controversy surrounding the February 8th elections. And as a result, there are also a number of concerns with respect to the legitimacy of the current parliament. Nonetheless, given that the parties forming the government do not have a majority, or do not have a two-thirds majority in the parliament, so as such the government's desire to amend Article 63A of the Constitution also raises a number of questions with respect to the government buying loyalties of members of other political parties to get this amendment to pass. Nonetheless, it is also important to bear in mind that until this amendment is passed, the interpretation of the Supreme Court in the Supreme Court Bar Association case will hold the field. And as a result, as far as this amendment is concerned, any member of a political party may not cast his vote contrary to the party's directions, and any votes cast in a manner which is inconsistent with the party's directions cannot be counted. Now, perhaps the most controversial aspect of this amendment is the creation of a federal constitutional court. Now, the most obvious aspect of this decision is that it relegates the Supreme Court of Pakistan as the second most important court in the country. The Supreme Court of Pakistan at this juncture is the highest court in the country and is the final arbiter of the law. And given that the government has had to face a few setbacks in the Supreme Court in the last few months, the creation of a federal constitutional court is tantamount to frustrating the Supreme Court's attempts. Now, this sets an extremely dangerous precedent because what this suggests is that every time the government is unhappy with a decision rendered by the Supreme Court, the government could, instead of complying with such decision, create a supra court. It could create an additional court and transfer all constitutional cases or any case that catches the government's fancy to such court. Now, tomorrow, for instance, if there is a decision that the Federal Constitutional Court renders which the government is unhappy with or which ruffles the government's feathers, the government could simply create a supra-federal constitutional court and as such strip the Federal Constitutional Court of its jurisdiction. Given that the Supreme Court has time and again held that the independence of the judiciary constitutes a salient feature of the Constitution, the Parliament does not have the unbridled power to tinker with the Supreme Court's jurisdiction and impinge on the court's independence. The other aspect of this amendment is that it states that instead of the senior-most judge becoming the Supreme Court of Pakistan, as has been mandated by the 18th Constitutional Amendment and as has been recognized by the Supreme Court in the judgments of Al-Jihad and Malik Asad Ali, this amendment states that the government may select a Chief Justice from a panel of senior-most judges. Now, given our history, the life of law is experience. Law cannot be understood in isolation. Every constitution, because a constitution is at the end of the day a country's social contract. It represents a country's social contract. And in the words of Justice Holmes of the US Supreme Court, the life of law is not logic, the life of law is experience. Given that our history is replete with instances where the executive or the parliament has attempted to impinge on the independence of the judiciary and emasculate the judiciary, such powers are tantamount to encroaching on the independence of the judiciary and ostracizing judges who are independent and judges who are not susceptible to influence. Let us also bear in mind that the current Chief Justice of Pakistan is set to retire in the next few weeks. And given the surreptitious manner in which this amendment is being instituted, there are also concerns that this amendment, the purpose of this amendment is to obviate the incoming Chief Justice, Justice Syed Mansoor Ali Shah, from taking oath as the Chief Justice of Pakistan. Now, the timing of the act. Ultimately, as I said earlier, the Constitution forms the social contract between the citizens and the state. And the greatest stakeholder in the Constitution is not the Parliament, not the judiciary, not the executive, but the people of Pakistan. Nonetheless, given the surreptitious manner in which this amendment has been brought, given the mystery that this amendment has been shrouded in, and given the haste in which the government is attempting to bring this amendment, this betrays the government's malice. And as a result, given that the people of Pakistan, who were the greatest stakeholders in this process, the people of Pakistan have been kept in the dark. Now, we have seen that throughout the world, especially the Colombian Constitutional Court has invalidated acts passed by the parliament on grounds of insufficient democratic deliberation. So as such, this amendment, if it is passed, would also fall foul of this principle. Constitutional amendments cannot be passed in the manner in which the government is attempting to pass this amendment. Constitutional amendments ought to follow a process of debate and deliberation. One more interesting aspect of this amendment is that while the law minister in the parliament today attempted to say that this amendment is an attempt by the parliament to reclaim its space, to ensure that the parliament controls this country's destiny. Nonetheless, this amendment also amends Article 243 of the Constitution to state that the Parliament would now, after this amendment, not have the right to amend any law which deals with the appointment, extension, or reappointment of service chiefs. The only manner in which the Parliament can affect such laws is then through another constitutional amendment. So far from reclaiming space, the Parliament is once again ceding space through this amendment. So as a result, this amendment is a malicious attempt to emasculate the judiciary, and this amendment is an attempt to weaken the democratic structures and the democratic institutions which ensure the citizens' freedom. I think it is important to acknowledge that notwithstanding this amendment, Justice Mansoor Ali Shah would be the lawful and the constitutional Chief Justice of Pakistan on 26th October, and any attempt to hand over the office of the Chief Justice of Pakistan to any other person would fall foul of the principles which underpin our democratic dispensation. We have seen that attempts to emasculate the judiciary, whether in 2007 or whether through the reference against the current Chief Justice in 2019-2020, are the harbinger of further chaos and disaster. Nonetheless, given the government's attempt to bypass the parliament and bypass legitimate democratic procedures to get this amendment passed, all that this shows is that we have learned nothing from history.